Welcome to the September 27, 2011 meeting of the Glendale Housing Authority. May we have a roll call, please?
Authority members: Friedman.
Here.
Manukian. Here. Mincy.
Here.
Najarian.
Here.
Parazian.
Here.
Weaver.
Here.
Chair Quintero.
Here. May we have your report?
The agenda for the September 27, 2011 regular meeting of the Glendale Housing Authority was posted on Thursday, September 22nd on the bulletin board outside City Hall.
What's next?
Approval of minutes.
So moved.
Second.
Minutes stand approved as submitted. Next.
Next is oral communications, but no cards were submitted.
And next.
On the business agenda at 6A is Director of Community Development regarding follow-up actions for Section 8 waiting list overview report. At A1 is a motion to receive and file report and provide direction to staff.
Mr. Scarborough.
Yes, we go to Peter Zovak for the staff report. Peter?
Members of the Housing Authority. At its meeting of May 19, 2011, Glendale Housing Authority.
Thank you. There we go. Thank you.
At its meeting of May 19, 2001, the Housing Authority received an informational report regarding the Section 8.
On now? I'm sorry. Yeah, there we go.
Third time's a charm. At its meeting of May 19th, 2011, the Housing Authority received an informational report regarding the Section 8 Housing Choice Voucher waiting list. That report provided a summary of the Section 8 Housing Choice Voucher waiting list with regards to the establishment of the waiting list preference point system, timelines, and operational procedures, and how the waiting list is managed. At the meeting, and just to recap, the last open enrollment for the Section 8 program was in January of 2001. Over 12,000 applications were received. Currently, over 5,700 applications remain on the waiting list. No new vouchers have been issued in over a year.
Pardon?
It's not working?
At the meeting, the authority and CD staff discussed several proposed actions that could be taken to generate movement on both the waiting list and on the Section 8 program. The Housing Authority directed CD staff to further explore these specific tasks and report back. Those proposed actions were requesting voluntary removal from the waiting list for those households currently being serviced by Section 8 portability, conducting a one-time purge of the entire waiting list, and conducting a systematic criminal background screening of all Section 8 participants. The first two tasks are expected to impact the current Section 8 waiting list, potentially reducing the size of the number of the applicants on the waiting list. The third task is intended to address those households currently receiving Section 8 assistance. And we'll go into that. Different staff members will be presenting different elements of this report. With regards to requesting the voluntary removal from the waiting list of households currently being serviced under the Section 8 portability. As you know, the Glendale portfolio for vouchers consists of vouchers allocated directly to the City of Glendale via HUD, approximately 1,592 vouchers, and then nearly equal number of vouchers that are issued by adjacent other housing authorities, in which the household then moves into the City of Glendale. That voucher is then administered by the Glendale Housing Authority staff, and those are called portable vouchers.
I'm sorry, could you go back to the last slide? And is there a typo on the middle bullet point?
HUD regulations prevent removal from, correct, it's a typo, removal from the waiting list.
Removal of names from the waiting list.
From our waiting list?
Correct.
Okay, which is different than what the proposal is to remove them from the portability, the ported.
No, let me get into that. Okay. So what staff did is we went ahead and took a look at a snapshot of our existing clients on the Section 8 waiting list, approximately 5,700 households. We then took a look at the portable vouchers that we administer predominantly for the Housing Authority of the City of Los Angeles. And we identified approximately 120 households that are being serviced via Section 8 portability that also appear on the waiting list.
Oh, I see. Okay.
So HUD regulations prevent anyone from forcibly, an agency from removing someone on the waiting list, but in essence what staff feels is that it's really a tying up of resources. It's duplicative service. There is no differentiation between a Section 8 portable versus a Section 8 voucher. There's no more guarantees, no more safety afforded to a household. It's administered by the agency in which the household is living in. In this case, the Glendale Housing Authority administers that portable. There really is no reason in looking at the demand of over 5,700 people on the waiting list why those households should remain on the waiting list, although we can't remove them. So we were proposing to have some outreach to those households, let them know that they continue to appear on the Section 8 waiting list, that they've been serviced under portability, that there is no advantage to remaining on the wait list. That wait list position cannot be gifted over to any other household. You cannot add any household members. You can't in any way try and manipulate it so another household might benefit by your position. And we feel once we're able to explain that to them, and in some cases I think once we remind some households that they still continue to be on the waiting list since it's been so long, we feel that many might forget that they appear on there. We think we might be able to generate some number of people that would voluntarily remove their name from the list, considering the fact that they're on the portable program.
If I may. So how did they get to that situation? They applied to the
They
Glendale.
can apply at multiple agencies.
There's no restriction.
No.
And there's no residency requirement that you have to be a LA resident versus a...
There could be. Those agencies might have already burned through their residency preference points and started to serve those on the outside.
I see. Okay.
We might add, there was a time when LA lifted their residency requirement.
year.
They used to be a year. They were in trouble getting their vouchers placed, so they lifted their 1 year. It's been 5, 6 years ago, 7 years ago. As a result, we took a large number of portables at that time, came into Glendale.
They're back currently, I believe they're back at having certain, at least a year of residency in the city of LA before they issue the voucher.
Although they could try to ask for a reasonable accommodation.
They do have
findings for that.
Right. Medical accommodations
Correct.
and medical reasons they can have it transferred.
Correct. So while staff sees this as being duplicative and taking up space on the waiting list, we thought we would at least come back and inform the Housing Authority that we do intend to reach out to those 120 households and let them know that they continue to be on our program list. Again, brief them on the differences, actually no differences being between the two lists, and see if they'd voluntarily remove their name. So that's the one method of trying to reduce the wait list, albeit small. I think the chances of success for those 120 are very high. And then I'm going to ask Joseph Rodarte, Administrative Analyst, to take us through the second recommendation, and that would be conducting a one-time purge of the entire waiting list.
Be clear, if one of those portables names came to the top of the list and we were issuing vouchers, what would happen?
We would qualify them, and we would ask them at that time, do you wish to remain a portable, or do you want to convert to a Glendale voucher? And for whatever reasons, they might elect to convert to a Glendale voucher and free up that
In
portable.
which case, the
back to
portable would
original
go back
agency.
to the other city.
Correct.
So as it is, by them volunteering come off the list, they can actually help us create more vouchers for Glendale residents.
Well, they'll hopefully they would, yes. They'll certainly remove people from the waiting list that allow people to move up.
But likewise, we wouldn't, as long as they're here, we're administering the voucher. They're living in our community, like anybody else on Section 8. And in reality, then, they're let's take LA as an example. They're using one of LA's vouchers to live in Glendale.
That is correct.
Which is a benefit to us and a benefit to them. In that case, then, somebody else in Glendale could then use the local voucher, as
That is
opposed to
correct.
somebody having to meet whatever requirements LA has and then someday try to transfer back to Glendale.
Exactly, yes.
What if, let's say I have an LA voucher, and I have, my name is still in the Glendale system also, and I do get it was transferred over, so I'm living in Glendale, I'm getting Section 8. Do I feel as secure having this still on the LA? I know we run it. I mean, we're servicing everything. But since it's LA, could they withdraw it at some point? Or would I feel better that my voucher is in Glendale?
Just to back up, you're correct in that the household only deals, a portable household only deals with Glendale staff. So they have really no connection back to Hawkla other than the fact that they originated the voucher. The only difference might be, or concern a household might have, and this is something we'd want to walk them through that, is if and when there are ever any type of budget cuts that are implemented and possible terminations, that at some point in time an agency might look to portables as a possible solution to their financial straits. So it could always be in jeopardy from terms of a budget cut. We've never seen it that way, but that would be the only downside to it. But then the question would be whether or not Glendale is any stronger financial position than any other housing authority. All housing authorities are being cut financially. As a matter of fact, we want to bring in a couple of weeks an update on the Section 8 budget and the recent announcements as to funding for this current fiscal year. With that, I'll ask Joseph Rodarte to come up.
Good afternoon, Mr. Chair, Housing Authority members. I'm here to present the second portion, or the second option, regarding the waiting list purge. Back in May, the Housing Authority asked the Housing Authority members asked the Housing Authority to come back with another viable option, determining whether to how individuals can move on the waiting list. One of those options was the waiting list purge. Applicants, just to give you a little bit of background on the waiting list and the purge process, applicants are required to respond to Housing Authority updates as we send them out. If they do not respond, let's say, for instance, they do not return the correspondence or are unable to, for whatever reason, an address is undeliverable or something like that, we make our efforts to go ahead and make additional contacts with them, look in their file, and see if there's other avenues we can go ahead and contact them with. If they aren't able to be contacted, then they are then sent out a letter for record purposes that they will be removed from the waiting list. That's called purging. We do that typically 200 have been doing on a monthly basis, with a good portion of that coming back almost undeliverable because we need to basically update our waiting list. We recognize that this was a possibility of conducting a one-time large purge of the entire waiting list. 5,700 individuals are currently on that waiting list, and we would like to, or one of the possibilities was to go ahead and purge that list either through two viable options. The two options that we are presenting today is a third-party vendor and an in-house option. In consulting with other housing authorities and other housing authority organizations like NARO, we presented and put out feelers to get an idea as far as what other individuals have been doing. We came back and we received one third-party vendor to give us an estimate, and this is just for merely an example purposes. Obviously, if you decide to go with a third-party vendor, we would like to go through an RFQ process to make the process as fair as possible. The individual that submitted, or the group organization that submitted an estimate, which is one of the exhibits, was Los Angeles Lomond. They are an affiliate of the Housing Authority of the City of Los Angeles. They have over 739 contracts in public housing, over $350 million, covering over $350 million. So they're a pretty big organization. They submitted a project that would be covered in 5 phases and would roughly take about 40 days to complete from beginning to end. And that project's fiscal impact would be anywhere between $25,000 and $31,000. Another option was also the in-house option, and that in-house option, the Housing Authority envisioned a senior staff member organizing a group of individuals that have previously worked in the organization, either through the GYA organization, and have proven themselves to be an asset to the organization and has proven to be successful in these types of projects. The mailings to La Paloma, to Vassar City Lights, they have been successful in those areas, so we figured that would be a good place to start as far as the in-house option. That would then be, the project would then be run by a senior staff member appointed by the Deputy Director of Housing at that particular time. There was advantages to both, as listed in your report, but just to highlight a couple of them, the third-party vendor option presented minimal interruptions to business operations. Basically, they could be housed off-site or in a small isolated area of the office where they'd be able to conduct their own business, be led by their own project manager with minimal interruption to the daily operations of the housing authority. Two, a shorter amount of time to complete the project. Their proposed time would be 40 days to 2 months approximately, which is a rapid turnaround for the type of project that we're looking at, which is 5,700 vouchers or 5,700 individuals being contacted. And lastly, the relatively inexpensive. We've had previous vendors that we've used to handle such things as the waiting list to intake. That cost over $175,000 at the time. This is nominal compared to that, but just as robust a task. And if we can go to the next slide.
How much is relatively inexpensive?
The relative cost would be $25,000 to $31,000 is what we're looking at. That was based on the estimate that was submitted by Los Angeles LOMAD. The in-house staff option also had its benefits. It provided more flexibility and familiarity. We would know the individuals. They've already been successful. They're familiar with our office practices. They would require less training required on our housing software. We have to have a way of having this information put back into the system. They've shown their capabilities as far as housing software, whether it be Word, Excel, and we have a specific housing software that they may be familiar with. Another identified point, is the security feature. These individuals have already been entrusted with having dealt with very client-sensitive information. So there's already that security factor built in. We know exactly the safety features as far as files are kept and everything, how they're locked. Customer service level. We envision that we will actually have to go out at some point and contact individuals either by phone to make the process faster. And we felt that being able to have individuals that speak Spanish, Korean, or Armenian would be highly desirable. And last but not least, we have better quality control. Obviously, if we're able to have it in-house, we'd be able to have more control features in place that would make the quality measures that much more. Therefore, incorrect Social Security, data input, that type of thing. Based upon the two options that we covered, a lot of the housing authorities seem to prefer having to handle the project themselves or slightly dissatisfied with some of the vendors they use. I'm not talking about Los Angeles LOMAD in specific. I'm just talking about their experiences. That being said, given all the attributes of both options, the housing authority feels that the in-house staff option would be preferable in this particular situation.
What would that cost be?
The cost for that one would be approximately $25,000 to $45,000, depending on the number of individuals that are selected and the duration of the project. Because that could be anywhere from, we're looking around a 4-month to 5-month time frame as opposed to 40 days to 2 months. There are other staff that are here available to answer any other questions that you may have, but that concludes my portion.
Why would it cost additional for staff to do it?
Excuse me?
Why would it cost an additional amount for staff to do it?
Depending on whether we select 3 individuals or 4 individuals or 5 individuals to handle the project.
But those individuals are there already, and we're paying for those individuals.
No, we'd hire GYA staff, outside contracted hourly.
So it's not staff doing it, you're hiring?
No, it wouldn't be. In-house would consider GYA as staff, hourly workers.
I see. Okay. And
We could get the same language capabilities?
We have individuals that we've kept track of that are very helpful when these projects arrive. So we've kind of have an idea. I mean, these are preliminary stages that we're talking about. So we have kind of an idea of the individuals that we would like to participate in this type of project.
I personally would.
That do have that type of language skills.
But we're not talking about hiring the youth, are we?
Yeah, we are.
There are some members. We are talking about using GYA association members.
Okay. Because I have some. I mean, I envision this to be a very sensitive conversation that may take place. Who are you? You know, are you so-and-so? And is this your name? Is this your ID number? And I'm not sure that our youth, although they're great at doing many other jobs, I think this job may require a certain bit of sensitivity, aside from language skills, to approach and to get the respondent to feel comfortable to give us the true. I mean, we want the true information. Is this you? Are you gone? Where's Mr. Jones?
We envision it being more along the lines of general information. The sensitive information would always be in the file. The general information is, where are you located? Where can we mail this to? Where can we send the update? And on a different note, I completely agree with the Housing Authority, completely agrees with you as far as the sensitivity of this, but these individuals have handled similar type application processes in La Paloma and in the Garfield or Gardens on Garfield and Vassar City Lights, so they are familiar with how to handle themselves. Just to hopefully that puts you a little bit at ease.
Mr. Manuki.
I just think the in-house option is a better option, and if we can have the GYA, either graduates or providing them with funding for work, I think that would be great, and it certainly will be rendering a service to the city as well. So it's something that should be done in terms of purging the list. I think a lot of these individuals who have applied probably have gone through other options at this point. So I think it's time, and certainly, like I said, GYA is a great option.
Any other, Mr. Mincy?
These GYA members aren't like, they're not out raking leaves. These people have had experience working
They have.
with us.
A majority of the
So it's a
individuals that we
difference.
hire on an hourly basis, majority of them, I would say, would have college degrees already. So, and are still participating in this type of work program. And it's an incredible program, I have to say. I mean, on a personal level, I've experienced and worked with some of these kids, I would say, because they're quite younger than I am, but their level of...
We call you a kid, and you call them a kid. It's all relative.
Their level of professionalism is comparable to anyone else in the office. Their skill level, their skill set, although quite young, I mean, it's there.
Personally, I'm for the in-house program.
Me too, I'm with in-house,
Okay.
especially for language skills.
Any other comments? All right, well, do we need a motion to proceed rather than to...
There's more of the PowerPoint.
Oh, there's still more. Okay.
We jumped the gun.
Well, for the first option, I guess in-house.
Good afternoon, I'm Carolyn Siegler, the Community Development Supervisor in the Housing Office. Good afternoon, Housing Authority Chair, Mr. Quintero, and Housing Authority members. I'm here to provide you some additional information on the systematic criminal background checks that we're proposing. HUD implemented some rules back in 2002 which required us to screen our applicants that are coming off of our waiting list and to also look at our tenants and ensure that they're not committing any crimes while they're on the Section 8 program. At this point, there's many tenants who are on the program, who got on the program prior to 2002, who have never been screened. Then we also have tenants on the program who maybe have been screened, but maybe they got on the program several years ago, and we haven't checked their criminal history. Also, we do send them a declaration. They come into the office every year and complete a declaration, and they do not disclose that they've been involved in criminal activity. So that's the reason why we're here. If you go to the next slide, okay.
So let me just understand, you're proposing screening individuals who applied prior to 2002?
We're proposing
Or on the-
to check all of our
Who have Section 8 vouchers at this point?
correct, current Section 8 tenants.
Okay. Why?
Because recently we've been getting some cases where there's some very serious crimes have been committed by some of our clients, and at the end I can go over a couple of case scenarios if you would like.
No, but we're going to go over all 3,000 cases because we have a few cases.
It's probably more than a few, but they're pretty serious crimes, and I'm the supervisor in the office. I get calls from the waiting list. A lot of people that
I
are...
get calls from the
I know you do.
waiting list as well.
I know you do. It's very difficult. You get calls from elderly, they've lost a spouse, their income has immediately been cut in half, they want Section 8, they can't get it. This is an option for getting some people off the program that are not following the program rules.
Okay.
So the HUD rules require that...
Okay, proceed doesn't mean, okay, I agree.
The program rules require that we terminate tenants who are involved in violent criminal activity, drug-related criminal activity, and any criminal activity that threatens the neighborhood. And I'll go over those. And also to let you know before that all of our clients are warned when they get on the program, and they're warned annually. They're given the information in 3 different languages that those are the rules, that you're not to commit violent criminal activity, drug-related criminal activity, or any criminal activity that threatens the neighborhood.
And I'm sorry if I may ask, the individuals who received the Section 8 vouchers after 2002 have already been screened, you said? Because...
Correct. And are reminded annually. Every tenant, every adult on the program has to sign 3 certifications.
How many Section 8 vouchers have we issued that are prior to? Because we started in 2001 with this...
2002, and I don't know the number that were prior to 2002.
Because there's only 3,000 vouchers, and half of them are from L.A.
Correct. And we
Does this include the L.A. vouchers as well?
This would include everybody on the program, all adults on the program.
Okay. So we don't know the number of individuals that are prior to 2002?
No, I don't.
It could be 1, it could be 2,000.
We're estimating in the report that there's 4,000 adults on the program, so it'd be a good portion of those. Also, even if they were screened in 2002, they haven't been screened since.
Okay, but if they were part of a criminal action, then you would probably know it, right? Because I know a number of them who have been taken off the program because of criminal activity.
Correct, and I'm going to go over the ways in which we currently do find out that people are participating in criminal activity.
And you said 4,000?
There's about 4,000 adults on the program.
But we have 3,000 vouchers that are...
Correct. We have a lot of elderly on our program. I believe the report says 4,400 adults on the program.
Okay. So it's 3,000 households then, not in...
Correct.
Okay.
So the HUD rules state that the members of the household may not engage in violent criminal activity, and they allowed the housing authorities to develop our own policies, with some policies. We adopted the policy that violent criminal activity was the use, the attempted use, and the threatened use of force that would cause bodily injury or damage to property. We also included crimes that were listed in the California Penal Code 1192.7c. Some of those crimes include murder, rape, assault with a deadly weapon, terrorist threats, intimidation of witnesses and victims. And we have terminated for those types of crimes. That's the violent criminal activity that we're terminating for. And then the drug-related criminal activity, HUD required that the PHA establish standards to terminate assistance for families under the program if any family member is currently using or has a pattern of using illegal drugs. We're using the definition for an illegal drug, the illegal manufacture, use, possession, sale, distribution of a controlled substance defined in Section 102 of the Controlled Substance Act.
Would you remind, I need to be reminded, when we're talking about a family, now what is the age of the kid that's, in other words, I'm thinking we got a young man who's now in trouble. His family have never been in trouble. At what age is he part of that family? And that would affect it, wouldn't it?
Yeah. It includes all household members, even if it's a child, but we are not running children through the criminal records check. There is some new stuff coming out with the sex offenders, and they're going to want housing authorities in the near future. We may be coming back on this. They want housing authorities to run the children through because housing authorities have children above the age of 12 that are registered sex offenders.
So it would be 18 and older.
Right now, we're only running adults, and that's all we're proposing to do at this moment. The last category of criminal activity that HUD asked us to address was criminal activity which may threaten the health, safety, and the right to peaceful enjoyment of the premises by other residents or other persons in the immediate vicinity. And examples of that, and some of the ones that we have terminated families for, would be theft, prostitution, graffiti, gang affiliation and activity, and multiple driving under the influences. We have been running criminal history checks since 2002 until present. We have run 1,150 adults through the system. Those 1,150 adults were either persons that were processed from the waiting list, persons who wanted to be added to a current Section 8 household, or maybe persons that wanted to be added to the household as a live-in care provider.
So quick question. After 2002, anybody coming on had their background checks run.
Correct.
But we didn't go back and do it again. So if you came on in 2002, it's been 9 years since you last had that check.
Correct.
Okay.
Can I ask a question? So the 13% of the households came back with a positive criminal record, but you only terminated 32 out of the 147. So can you give me some examples of the types of crimes that weren't considered serious enough to terminate them?
Yeah, maybe intoxication in public, one single driving under the influence.
So it doesn't. It's not differentiated by a felony versus a misdemeanor, that sort of thing.
No. It's violent criminal activity, drug-related criminal activity, and then criminal activity that threatens the neighborhood. So one single driving under the influence, we didn't terminate for that. Also maybe petty theft.
So
Driving without a license will also appear on your criminal record, but we're not going to terminate for that either.
is that a discretionary decision that staff makes, or is there a clear list of offenses that place you either on your out list or you can stay list?
I do have a list of the ones that I feel fall within the category of being a threat to the neighborhood. I consult with our fraud investigator, and we consult also with the police department. And this is kind of where we've drawn the line with the crimes that I've listed on the previous slide: prostitution, gang activity, graffiti, grand theft. We've had carjacking. Those are threats against the neighborhood where somebody driving without a driver's license might not be.
So someone driving without a driver's license with no insurance, who could cause property damage, who hasn't passed a driver's test, who maybe isn't capable of driving, you don't consider that a threat to the neighborhood?
We haven't terminated for that reason. I've had some cases with driving without a license and driving with a suspended license. I've had cases where I have one gentleman who had 5 arrests. 3 were for reckless driving, 1 was for burglary, and 1 was for drug possession. We terminated him.
Well, I'm not sure I agree about the driving without a license not being a threat to the neighborhood. I mean, if you don't have a license, you don't have insurance, you may not have passed a driver's test. I mean, we've got people on the waiting list who are law-abiding and deserving, and then we have people who are choose to break the law. Just concerned that I know you want to be tolerant, but where that line is, I'm a little concerned about.
Well, let's talk about that line. You talked about arrests. Now, there's a difference between an arrest and a conviction.
Sure.
Are you making that distinction?
When we find out that someone's merely been arrested and there's no disposition on the case, we'll wait till the case has been adjudicated. I feel more comfortable going to a hearing when I've got a conviction. I don't want to go to a hearing where somebody's been arrested twice and the case has been dropped twice. I don't feel like I have a strong case.
Yeah, I don't think you should go on arrests at all.
I don't. I go with convictions when I want to terminate a participant from the program.
The other issue is there are some legal procedures and legal cases. For example, your 1197.2 cases where the criminal system encourages a guilty plea, such as a possession, even of a narcotic, and a submission to the diversion program. So you enter a plea of guilty. You tell the judge, I plead guilty to this. The judge holds your conviction. You attend the drug education classes, the drug rehabilitation program, and should you come back successfully completing completing it, then the judge essentially dismisses the case. So I guess my problem is that rather than, and many times, my own experience, that someone who would have a legitimate defense to a criminal drug charge is oftentimes encouraged to submit a guilty plea, attend the classes, and have that case entirely resolved. Now, I'm not sure how we would deal with that. You may see that as, well, you pled guilty to possession of cocaine or of heroin or of concentrated marijuana or whatever the particular drug is. Yes, but my attorney told me to do that, and the DA gave me a deal, and they said the whole thing would be wiped off my record if I attended the drug classes. So, I mean, that's just one example of where the legal system is not in exact coordination with what we're looking for. And in fact, we may be a little more, it sounds like we may be a little more strict than what the California legislature and the people of the state of California wish to impose on a defendant who is charged with a drug possession.
I haven't.
See that sort
Yes,
of-
I do see that, and I haven't encountered that. Mostly, when I'm terminating someone from the program, there might be it's called NOLO. I forget what the real word is, but it's where they plead guilty to the
contest,
charge
essentially.
and accept a lesser charge. But most of the time, those are accompanied with some other convictions, and it's usually an extensive record of violent criminal activity.
Well, so we're sort of separating out different categories. One is the violent activity, threat to the neighborhood. The other are these drug charges that may or may not be a threat to the neighborhood and may or may not be something that is in the defendant's best legal interests to challenge and to take to it. I mean, your option is you take it to trial, which costs thousands of dollars. You throw yourself at the mercy of a jury, whereas they're dangling in front of you. Just plead guilty, go to the drug rehabilitation classes, successfully complete it, and we'll we'll throw your record away. I'm not sure if that's something that, and I do know that law enforcement agencies still have that on their record as a diversion, a successful completion of diversion, and private employers don't have that. So I think our city attorneys are probably familiar with that, and maybe this is I guess my point is that as we go through this criminal check program, and if we decide to use that as a criteria, there are certain instances where it may be inconsistent with our ultimate goal and may be detrimental to a defendant who is receiving advice from a criminal attorney. And in fact, sometimes from the judge. The judge says, look, all you have to do is plead guilty to this, attend the classes, and this thing is gone. Don't tie up my courtroom time with a trial and a preliminary hearing and all these other things just to contest this possession of cocaine charge. So,
Vice Chair Najarian, if I may, just to reiterate a statement that Ms. Siegler made earlier, is that oftentimes what she does is when she does see a record, and one thing she did mention is that oftentimes it's not just one record or one incident. It's usually a pattern. For those cases, though, when there is one incident, she will consult with other staff members. She will, if it's taken place in Glendale, she will consult with the Glendale Police Department, with the arresting officer, to get some more information as to how that arrest took place, what the circumstances were. That applicant or that tenant will have the ability to come in, request a hearing, be able to plead their case. If indeed they've gone through some type of diversion program successfully and there are some unusual circumstances as to their arrest, they're going to be able to make that case in front of an informal hearing officer. Prior to that, they're able to make that case to Ms. Siegler as well, and then she has the ability to take that all in and make a final decision. So it's not just the facts comes in, there's a conviction, they're terminated. There's more thought that goes into that process and that decision.
I guess my point is there are some very subtle nuances to the whole criminal procedure that even your basic attorney that does not practice in criminal law is unaware of. So to place that all on our on our staff may be I mean, you're almost being a judge, and you're, learning the difference between intent and all, the wide range of issues that our judges face. In fact, many times the value of a Section 8 voucher is far in excess of penalty that a criminal court would impose on a defendant. So I'm just saying you've got a pretty large burden on your shoulders when you have those hearings.
It's huge. You're taking away somebody's Section 8 benefits because they've, violated the program rules. It is huge.
And let me just add to that. You're not just being a judge, you're being judge, you're an executioner, from what I see. And that is a difficult task for anyone. But going back to the issues of driving without a license, I don't consider that actually a danger to the neighborhood. Sometimes we have to remember that Section 8 recipients are low-income individuals and low-income families where sometimes they have a necessity to go to work. They could have a suspended license, and they would have to, and I know circumstances where they've had to drive regardless of whether it was suspended or not, so they can go to work. So I think these issues are very sensitive, and they have to be looked at in a very careful manner, because if one of the children of a family does something wrong, the whole family suffers, and I don't think that's proper, especially when it's dealing with driving without a license. A lot of these kids take their friends' cars sometimes and do stupid things just because of that. They shouldn't be. Their whole family shouldn't be suspended. But I think the key word that you mentioned is a pattern. If there is a pattern, and from what I understand, that's what you look for. If there is a pattern, then I agree. Then there is a problem with the individual. But is there any counseling that goes on to when we notify these families that, listen, you have one driving without a license. These are the rules. Don't make it a habit, because you could lose, your whole family could lose the Section 8 housing. In that instance, we could be relegating them to homelessness, basically,
Yes,
or something else. So it's a very touchy situation.
Yes,
So-
there is counseling that's done. They're brought into the office with the housing advisor, and they go over the rules again with them. We even have some families that we put on an annual, we're going to do a criminal check on you annually because we need to, and a lot of times that's a diversion for the family not to commit any more crime.
Right.
If to approve somebody to get on the program, they can't have any of that criminal activity on their record for the previous 5 years. If maybe 6 years prior they had a long string of history, we'll bring them in, we'll talk to them, we'll make sure that they understand the rules of the program. We'll tell them we're going to put you on an annual criminal records check. We've done that several times.
Okay. All right. I just want everyone to remember that these are people and families we're dealing with, not just cases.
We do try to remember that. Ms. Siegler's been involved with the Section 8 program here in Glendale for how long, Carolina?
29 years.
29 years.
I know. I remember in 2001 when we did the lottery, she was there. So.
So she's very knowledgeable and takes her job seriously, takes the job of recommending terminations even more so seriously. And she often goes for additional advice, additional thought from others in the office and over at Glendale Police Department. Just to go back to the one example of a one-time incident, annually when applicants come in for their recertification, on the form there are sections of the application that state within the last year were you arrested or any adult household member arrested. That's one of the forms that we go back to if indeed we do find that there's been an arrest. If someone was arrested in 98 and in their next annual recertification they answered no to that question, that also makes us want to ask for the questions, why did you not reveal an arrest in this particular case? So we look at many different things to try and make a recommendation.
I guess I'm somewhat surprised that there is that much leeway in what housing staff can do. I thought when the Congress passed this law that it was pretty sort of cut and dried, but in fact there is some, or is there?
Well, there's maybe a little bit of leeway when you look at what crimes are a threat to the neighborhood. So we've listed those, and if it's on that list in my office, and looking at how frequent or the pattern of it, then deciding what's not a threat to the neighborhood. So I gave you some examples.
Right.
Well, there are some crimes that clearly, violent crime and gang activity clearly is removable. That certainly shouldn't happen, and especially if they lie about it, they should be out, clearly. But we're talking about, driving without a license. That's, sometimes that's done out of necessity.
Right.
So.
I don't know where I left off on this slide, but I think we had 1,550 adults that have been run through the criminal records check.
1,150.
Oh, 1,150. And 147 of those families came back with a positive criminal record. We used the live scan fingerprints, and I believe it comes down to about 3% of the total 1,150 that actually get terminated. So out of the 147, we terminated 32 families, and 115 were counseled and allowed to stay on the program. My last slide, this just shows how staff does learn that somebody's been involved in criminal activity. We have a staff member that reviews the public arrest records from Glendale Police Department booking. Unfortunately, this only shows Glendale arrests, so if they're arrested in a surrounding city, we're not going to learn about it through this. The clients do self-report that they've been arrested. Sometimes we call them in for their annual. They're not able to come in for their annual. They're in jail. Or a family will report that somebody actually in their family.
That's a sign they're in trouble, right?
Big sign.
He's in jail. He can't make it.
We've had households state that.
Yeah.
Well, that's good. At least they're honest.
Yeah. There.
As opposed to he's in.
What happens if, I'm sorry, Mr. Ninja, what happens if one of their family members, let's say the parents have 3 kids and one of the kids ends up in jail, does the whole family lose really?
Yes. It says crime by any family member for the whole entire household.
As long as they're under 18, over 18?
There was no age stipulation. We had a minor commit murder, and the entire family was terminated from the program. The family was going to accept the child back into the household, and so we terminated the family. Or maybe they voluntarily withdrew. I can't remember now.
If they don't accept the child back in the household, the family's okay?
No, but in this particular case, they were very forthright, saying we're not going to not accept our child back into the household. We want him back in the household, so
Okay.
terminated the family. The other way we learn about the arrests are from property owners and managers and neighbors. They'll alert us if there's been criminal activity or multiple times that the police are out to the unit. We also coordinate very well with the Glendale Police Department. They have access to an address list. They will let us know if they're going to an address repeated times. They'll come and talk to us. We do also periodically scan the newspapers if we see a name that looks familiar. We've learned about it a lot that way. And we do monitor 2 sex offender websites. We do that about
Which
twice
website?
a year. The Megan's Law and the, I can't remember how to say it, Dro Soden, I think that's the way you say it. It's 2 websites. So that's it. We're proposing to review, screen all the tenants on the program and terminate those that violate the program rules to maybe free up some vouchers for those persons on the waiting list.
Am I correct that you said it's only Glendale Police Department arrests? What if don't they know about Burbank or some other place?
Right now, we just have staff checking the Glendale booking on the city website.
There's not a state list or anything like that? Or?
No, not that I'm aware of. I mean, we could look into our 2 neighbors.
Well, look, I'm for this ongoing screening, and Yeah, I'm surprised that we're not looking at LAPD, since quite often criminals don't necessarily commit a crime in their hometowns, go somewhere else to do it. But, I mean, I think this is a good idea, and I like the fact that you and other staff members can review the issues and see where it's warranted and where it's not. But there's an awful lot of good people that are trying to get on Section 8 that are not afforded the privilege, and so I think we should move forward with the review. So, Mr. Zovak?
Just to emphasize that what we did is we discussed a very small number of cases from our program. There are a lot of good families that are on the Section 8 program. So what we pointed out was over a number of years, some more recent though, and some of the worst examples that are out there. But a majority of our program participants do comply. There are good people. They are good neighbors. They're good residents. What staff outlined in the report is there's really two options we could consider, or the Housing Authority could consider, to implement this criminal background screening. One is a one-time screening of the entire program over the course of 12 months. So as households come in monthly for their annual recertification, we would have them go through their criminal background screening at that time, and it will take 12 months to complete the entire program. The other option is to do that exact thing and then alternate in year number 2 to have a certain percentage of the program screened again. In years 3, a certain additional number of program participants screened again, so that it's a continuing screening of a percentage every year. At this point, staff would recommend that we do a one-time screening that takes place over an annual basis, and if staff feels there might be a need on down the line, say 5 years from now, that we would come back and propose that again. The one-time annual screening comes at a cost of a little over $100,000. There are sufficient reserves, admin reserves, in the Section 8 account to pay for that, approximately $3.7 million to pay for this proposal, as well as the up to $45,000 proposal for the in-house waiting list purge. To implement the criminal background screening, staff would have to come back to have you adopt an amendment to the Section 8 administrative plan that calls for that one-time screening.
Okay, well, I'm comfortable with it. Mr. Najarian?
Question. So staff thinks this is a legitimate criteria to put forward for the Section 8. Would it also be a recommendation to put it forward for all our low-income housing? Would it also be your recommendation to put it for our homeless housing? Would it also be a recommendation to put it towards some of our veteran housing that we're talking about doing?
Currently, those other programs you mentioned, I'm not aware of them requiring any criminal background screening the way that the Section 8 program does. So at this point, the recommendation only reflects the Section 8 program.
We don't administer those programs either. I mean, the low-income housing programs, it's not, they're non-profits rather than administering it.
Correct.
But in answer to your question, Mr. Najarian, yeah.
They should anyways, yeah.
They should.
Well, wait a minute. Some of the veteran housing, I mean, we know that they have had issues before. They're undergoing counseling, let's say drug rehabilitation, which is I'm fine with, but by our own standards, that would exclude them from, if we impose the same standards we're applying to the Section 8, that would certainly create an issue where they would be reviewed. So,
well, but I don't.
Is that what we want to do, though?
Yeah, but I don't think so. I mean, I agree with you for vets specifically, and also for homeless, but that's where the staff comes in. I think that's where the staff has the leeway to judge, or at least have some general idea of what that person or even that family's demeanor might be, then, it would apply. And some people, may not get the opportunity to live in an affordable housing unit or get into a veterans housing unit, whenever it's built, because it's just not going to work. So I didn't even think about that, but I'm glad you mentioned it, because I also think that's a good idea. I don't know what the cost associated with it would be, but...
Is there an appeal? Let's say staff makes a decision one way or the other. Well, one way. If it's the other way, let's say staff makes a decision based on your review of your criminal record and our concern for whatever criteria that they haven't met. Are they permitted currently to bring it to any other body for review? The housing authority? Presumably should have the ability to review.
There's a hearing.
No, there's
The
a
hearing
process.
officer, isn't there?
When someone's recommended for termination, they're given the information, the reasons for the termination, and their rights to an appeal process. The appeal process involves an informal hearing officer that the housing staff contracts out with. Both sides then make a presentation before the informal hearing officer. The officer then renders a decision. And then if
Is that
the
housing authority policy, or is it...
Section
or is
8
it
Housing Authority
Section
policy.
how?
I mean, do we have like a...
Is it a policy, or is it...
certiorari to the
Can we change the policy? That's the
council
question.
or to the authority?
If I'm not mistaken, it's a mandated policy
Okay,
by
that's
HUD
the
to have an
question.
appeal process.
I think both the due process and the HUD rules require this hearing, and that's pretty standard to have that hearing, and then that's the level of the hearing. And then they can take a writ on that if they...
So they come to us, and we get the letters and the emails, and it's I got a bum deal, and this is my real explanation, and the hearing officer, as an example, wasn't listening to me. She was very rushed. Here's my real case. Let me bring it. Would you please hear my case, housing authority? Do we have that ability to say, hey, well, let's listen to this?
That wouldn't come before you. Under the rules, it has to go...
Go to the judge across the street?
They would take a writ, so it actually would go downtown. But yeah, same concept.
Ultimately, they do have the ability to seek judicial review if they're not happy with the decision of the hearing officer.
And what we have experienced is they will also write to HUD. We'll get a letter from HUD.
Right.
Staff will end up writing a long report to HUD explaining the whole process. My guess is if HUD felt along the way there was some error made, they'd probably bring the matter up or require further review. We had one just recently. We got a letter from a lady complaining, or a gentleman complaining, about the staff's decision. It went to HUD. I got a letter from HUD that went to staff, and the staff had to write a rather long explanation of the whole history and determination on this individual back to HUD.
I mean, my problem in this whole thing is I want to be fair. I want to make sure that no one is dealt with unfairly, and if there's an extenuating circumstance, something that, the cut and dry requirements that we're going to be imposing, the criminal law, the penal code, et cetera, that we're as fair as possible, because this is such a huge, this is like you said, this is a life-changing thing to be able to stay in the program or out of the program. And I just want to make sure we have the safeguards and that there's a proper consideration done by staff, proper information and sometimes you get bad information also from police or from the databases that you search. I just want to be fair. That's the only thing I'd like to, take the bad guys out, open up spaces for the worthy families, but we have to be fair in all this. That's my only concern here.
Friedman?
Just to give my comments, I am for the waitlist purge with the in-house staff. I am absolutely for the criminal purge. Listening to staff and knowing staff, I know that they are very fair and very concerned, and that they see these families as their clients and their responsibility. I don't see them at all as being heavy-handed, having worked with them now for almost 3 years. And they've worked in this field for many, many years. I personally would not feel comfortable with appeals coming to us. I don't think that we're in any position to make that kind of determination. I do think that HUD and the people who are professionals who work with these clients day to day are in that position. But in terms of kind of letting people slide because they're poor, I just don't buy that at all. It's one thing if somebody, and staff uses their discretion. Listening to them, I'm very confident that they do use their discretion and try to find patterns of behavior that shows that people are really a problem. And certainly someone getting caught with a little marijuana once, or somebody who's caught driving without a license once, to me, I agree that they shouldn't be terminated for that. They should, however, be counseled and warned. But someone who has a pattern of behavior, even if it's driving without a license, to me, should be terminated, because The bottom line is that these programs, whether it's affordable housing or Section 8, they are not a right. This is a privilege. This is the taxpayers are paying for these people and only these people, even though there are thousands of other people who desperately want the same benefit, who are not getting that benefit. So with that privilege comes a responsibility. And to say that because I'm disadvantaged, I should be able to commit crimes without repercussions, and I should be able to get this great benefit, even though there's thousands of people waiting, I don't agree with that. I think that they do have a responsibility, and it's one thing to get caught once and get counseled and learn you have to follow the rules, but if somebody is breaking the law, even if it's driving without a license, which is breaking the law, they should not be in this program. There are many people who are law-abiding, who find ways to make ends meet within the law, and they should be given that privilege instead. And I would agree, I would think that we should extend that to our low-income housing as well if we can. I think that it really rubs people the wrong way when you have people who are desperate for these services, absolutely desperate, who are law-abiding, and then there are people that we know are lawbreakers, who are criminals, who have that privilege instead. It's just not right. And we shouldn't tolerate it to whatever extent we can't.
Okay, any other comments, Mr. Weaver?
In-house and the purge. Yeah.
Okay.
I noticed the motion here just talks about motion to receive, file report, and provide direction. But shouldn't we make that a little more substantial, talking about in-house, talking about the purge as part of the
You can
motion?
make the motion if you like.
Before the motion is made, I think Peter can briefly describe what's the next step with respect to the criminal screening as far as the plan. That way, that'll be part of your motion as well.
I think we should go with the 12-month, just do it and get it over with, yeah.
So that would be the one-time screening over a 12-month period.
And the in-house for the
Any future screening would be brought back to the Housing Authority for any discussion at a later time.
Right. Okay. And the in-house, of course, using the GYA.
Okay, do I have a second?
I'll make that motion.
Do I have a second?
Second?
I'll second then.
Okay. Comments?
I will support that motion and that direction, but I would like, to the extent that you're able to give us case summaries,
Right.
and be anonymous as far as I'm concerned. I'd just like to know if there are people that are getting dinged. Again, their names may be confidential and private, but I'd just like to know the types of offenses that have been committed that would cause you to give them the terminating sanction.
Just to clarify, that would be as we implement this monthly screening and we have instances in which we have recommended termination of a household, some type of write-up that doesn't disclose, that doesn't violate any of the confidentiality of it, but just some write-up of the following households were terminated, here are their circumstances.
Right. That's...
We could certainly, we'll talk with our city attorney office as well on that, but we can certainly provide something similar to that.
They could summarize the cause
And also the ones that you let, the ones
Stay.
that ones that you let stay, despite some red flags that appeared in the process, just so I can see how it's working.
And if I
That's a
may,
good
the
idea.
next step is for the Housing Authority staff to prepare an amendment to the administrative plan, which will give the criteria which are being used to trigger termination. It could also include the factors that would be used to make a determination whether or not termination is appropriate or no.
No, it is basically what was presented today in terms of violent criminal activity, drug activity, and other activity that threatens the neighborhood.
So that plan will show what triggers termination. So you'll be able to see that as well.
Okay, we have a motion and a second. Roll call, please.
Authority members: Friedman,
Yes.
Menuchyan,
Yes.
Mincy,
Yes.
Najarian,
Yes.
Karazian,
Yes.
Weaver, Chair Quintero.
Yes. What's next?
Next is authority member or staff comments.
Comments? I hear none.
Move we adjourn?
Second.
We are adjourned.
We're going to do the regular meeting and then join?
Do the joint meeting first? Okay, welcome to the September 27th, 2011 joint meeting of the Glendale City Council and the Glendale Redevelopment Agency. Can we have a roll call for the council, please?
Council members Menuchyan.
Here.
Najarian.
Here.
Quintero. Here. Weaver.
Here.
Mayor Friedman.
Here. Roll call for the agency.
Roll call for the agency. Thank you, Madam Mayor.
Agency members Friedman.
Here.
Najarian. Here. Quintero. Here. Weaver.
Here.
Chair Menuchyan.
Here.
Can we hear your report, please?
The agenda for the September 27th, 2011 joint public meeting of the Glendale City Council and the Redevelopment Agency was posted on Thursday, September 22nd, 2011 on the bulletin board outside City Hall.
Thank you. Mr. Starbird.
Yes, I go to Phil Lanzafame, Chief